Justice is here, and we got a guest on the horn. His name is Anthony Depew. He is from the Idaho Political Prisoner Foundation. Mr. Depew, thanks for being on the radio with us. Good morning.
Good morning. How are you today?
I am swell. So, thanks for being on. David, you take the bull by the horn since you talked to Anthony just yesterday, right?
Yeah, yesterday I had the privilege of interviewing Anthony on a Front Range radio station, and the interview was so good, I thought it would be a great idea to follow up with the conversation here in Montrose. He's been attending the trial down in Bunkerville. I don't know if it's Bunkerville where they're having the trial, but the incident that occurred in Bunkerville with the Bundys, Anthony's been involved in listening. He's a court listener, and so I thought I would yield my space to him to tell us his story, what he's experiencing, what he's seeing.
Anthony, go ahead. By the way, Anthony, are you a lawyer, or how are you able to understand code law?
Well, we've had enough time to kind of self-study. These guys have been in prison since March of 2016 without pretrial release, so kind of a trial by fire. I'm a web developer by trade, not an attorney by any stretch, but that profession kind of lends you to methodical thinking anyway, which is how the justice system works. It's a very methodical beast based on case law, and given enough time, just about anybody can kind of learn the ropes and start to figure things out.
Anything you've observed out of the ordinary?
Well, I don't think that anything that we're seeing in that trial actually is right down in Las Vegas on the Strip at the Lloyd D. George Federal Courthouse. I don't think that anything that we're seeing in there is anywhere close to the due administration of justice. We've got individuals now who have been denied pretrial release for 16 months. That's the entire Bundy family, by the way. They've imprisoned all of them. And some supporters who did nothing more than, travel across state lines to aid their neighbor and protest some heavy-handed overreach of the federal government. And they've been sitting in prison since early March 2016. So,
Anthony, if I may, can you be specific when you say the whole Bundy family? Can you be specific and just tell us who they are?
Oh, sure. Cliven Bundy is the patriarch there. It was his ranch that was the center of the issue. And then his children are imprisoned. Ammon, Ryan, Dave, Mel. And I feel like there's one more, and I'm going to, top of my head, I'm ashamed that I can't think of that name. Ammon, Ryan, Dave, and Mel Bundy, they're all in prison. Dave Bundy was arrested on April the 6th, I believe. He did nothing more than try to photograph some of the closure area that the BLM had closed off to round up some of his dad's cattle. And, of course, there was a sniper on the hill pointing a weapon at him, and he was arrested by a group of BLM agents who didn't even really have arrest authority. They just detained him for 2 hours after they roughed him up and then turned him loose. Then a couple days later, they were out there with dump trucks, and people wanted to know, well, what do you need a dump truck to round up a cow for? It turns out they were tearing up some of the water infrastructure that the Bundys had erected to not only water cattle, but any of the other wildlife in the area. So there was a protest there where Margaret Houston was body slammed for trying to look and see what was in a dump truck, and a attack dog was sicked on Ammon Bundy, and he was tased. And so those are some of the things that people saw leading up to the incident on April 12th that caused them to get in their vehicles and come and stand with their neighbor. And the government selected 19 of them out of the 400 or 500 people that were there. Selected 19 of them and decided to charge them with a litany of crimes that will net them an effective life sentence if they're convicted. And
Anthony, if I may interrupt just for a moment, for the listeners or new listeners or maybe people that don't really know what you're talking about, could you give us a little more context and lay the foundation of
Absolutely. Yeah, absolutely. My understanding is that sometime in the early 1990s, the government decides that Mr. Cliven Bundy should not be allowed to graze as many cows on the land that he's able to. They want to reduce his animal usage allotment by a significant amount that impacts his ability to provide livelihood. And so he stopped signing contracts with the Bureau of Land Management. And anyone who's been out to that part of Nevada, or really anywhere in the West, appreciates the scale of the West and understands that absolutely ranchers, recreationalists, even companies looking for minerals, everybody can share this land. There's more than enough land. There was always more than enough land for Cliven's cattle, and apparently there was an issue with a desert tortoise that was endangered. Bottom line is there's always plenty of land. I don't know that anyone's 100% sure why the government decided to do this, but Cliven Bundy just declined to sign a contract with the BLM, and instead offered to work with Clark County, who, arguably should have some level of control over the land. And after 20 years of legal wrangling and several court orders, the federal government attributes arbitrarily $1 million fine and grazing fees that are owed by Mr. Cliven Bundy. And the government, in their infinite wisdom, decides that the best way to recoup this arbitrarily arrived at $1 million is to spend $1 million on a contract rancher to come in and collect $1 million worth of cattle. And so the whole operation in 2014 was fiscally insolvent to begin with. Cliven Bundy owes $1 million, so we'll spend $1 million on a cattle rancher to round up $1 million worth of cattle to pay a $1 million debt. They're already going to be $1 million short, even if everybody volunteers their time. The whole thing is fiscally insolvent. And so you know that Mobil didn't donate the gasoline, and all the 100 and some agents that were involved didn't volunteer their time. So the government decides the best way to handle this is to spend millions and millions of dollars to go out into the desert and round up some cattle, and then, of course, try to sell them somewhere in the West, and nobody's going to buy Russell's cattle. So the whole operation was just a boneheaded approach to an issue that could have been resolved administratively, probably. And what happened was in 2014, the government decides they're going to round up these cattle. And Mr. Bundy petitions to the sheriff and says, hey, we've got a problem here. We have a land management issue, and we need the intervention of the sheriff. And the sheriff didn't want to have anything to do with it for probably various political reasons. And so he simply just said to Americans, hey, I've got an issue down here. Look at what the government's about to do to me. And when people took a look and they saw how heavy-handed they were, and I think the domino that started the whole thing was the establishment of what the Bureau of Land Management called a First Amendment area. They decided that if you didn't like what the government was doing, you could come and stand in a little parking lot that was taped off with construction fence, and a big brown sign with white letters that said First Amendment area. If you had an issue and you wanted to exercise your right to assemble and to petition your government for the redress of grievances and to exercise your free speech, you could only do it in this one little area. And that is offensive for people who live in the West. That's a very offensive proposition, that my First Amendment doesn't go with me wherever I go. That's not going to work. And so people en masse, really, responded to the Bunkerville area in early of April 2014. And everything came to a head on that Saturday. There was a rally in the morning, as there had been. The sheriff stood up and said, we've talked to the Bureau of Land Management. This roundup is over. Everything's going to be fine. Let's let cooler heads prevail. I'm kind of paraphrasing there. And so people left this rally site. A couple miles down the road is where these cattle were pinned up, and everybody collectively, independently, will tell you to this day that when they went there, they believed that those cattle had been abandoned or were in the process of being abandoned because the sheriff said the roundup was over. And when they showed up, instead of finding a corral with 400 cattle abandoned, they found dozens and dozens of heavily militarized federal agents behind a gate that the Bureau of Land Management erected, and an individual over a bullhorn on a windy day who said what everyone, whether they've testified for defendants or for the government, everyone has independently testified that they heard that the government was authorized to use lethal force. And in that group of protesters, you had men, women, and minor children. And so what were they to do? The protest turned into a very, very armed, tense situation, escalated completely by the federal government. Nothing had to escalate that day. The federal government did it when they pointed weapons at people who were lawfully exercising First Amendment rights to peaceably assemble and the Second Amendment right to keep and bear arms. It was, from start to finish, the whole incident was a lawful protest. The government escalated it into a standoff. And now their narrative in the courtroom is that Cliven Bundy orchestrated a massive, clandestine, interstate, massive assault against federal officers simply doing their duties and executing a court order. And that is who is on trial right now in Las Vegas. The government has separated these defendants, 19 of them. 17 decided to go to trial because they feel like they've done nothing wrong. 17 of these men are now separated into the 3 trial tiers. Tier 3 are what labeled as the gunmen, so they would be some of the individuals who are lawfully exercising that Second Amendment right. They had a trial back in February. 4 of the men resulted in hung jury across the board on all 10 charges. 2 men were convicted of various charges, and so now we are back in Tier 3 being tried again. And you wanted to know if there was justice, if there was any injustice. Basically what happens is if the government can't convict you the first time, if they can't get a jury of your peers to agree that you committed a crime, all they do is adjust their strategy and come back at you. And it's exactly what's happened with these Tier 3 individuals. All right now.
Anthony, yesterday you had mentioned a gentleman that was doing 70 years. We've got a couple of minutes before news.
We got 1 minute before news.
Could you quickly summarize that, and we'll come back on the other side?
Yes, Mr. Greg Burleson, he's an individual who traveled from Arizona to Bunkerville simply to come to the aid of his neighbor. He was at the protest. He was charged, and based on some things that he said by the FBI who plied him with alcohol while pretending to be a documentary company, they got him to say some terrible things. And because of the nature of the way it was charged, he faced 57 mandatory minimum years, and then they added about 12 years on top of that. He was sentenced to about 70 years.
The FBI gave him booze?
Yes, they staged themselves as a documentary company called Longbow Productions. Told him they were making a documentary. They gave him alcohol before they interviewed him, and then they led him into a very, very damning interview where he prolifically embellished his intent that day. And because of that, they were able to use the terrible things that he said to their advantage in the courtroom, and he was convicted and sentenced to 70 years.
Life sentence.
I got to take a break. Anthony, if you could hang out for 5 minutes, we'll be right back and talk to you again, all right? Hey, Anthony, how are you? Thanks for being on. So Attorney General Jeff Sessions is hopefully less belligerent than the previous Attorney General, but he chose not to take sides in this case. What do you make of that?
I think Jeff Sessions' behavior is telling. It's not just that he didn't take sides. He's also come out and said that he wants prosecutors to aggressively pursue lengthy prison sentences for various charges, which, believe it or not, is actually a departure from the Obama administration's policy of maybe not doing that. And that's an issue for this case because you have prosecutors, the U.S. attorneys have charged each of these men with somewhere the 16 total counts in the indictment, and they've charged it in such a way that these men will face an effective life sentence in prison. Ironically, in the federal statutes, voluntary manslaughter, if one of us were to walk up and stab somebody and kill them, statutorily, the most we would look at is a 15-year maximum sentence. And you would probably have to have criminal history to get the full 15 years. These individuals are charged in such a way that just because, for nothing more than exercising First and Second Amendment rights during a lawful protest, the U.S. attorneys, with the approval of people like Jeff Sessions, are charging these crimes and what they perceive to be crimes in such a way that you'll go to prison for the rest of your life. In this case, we have an individual named Todd Engel from North Idaho. He was convicted on only 2 counts, and they were considered to be lesser charges. basically interstate travel in aid of extortion and obstruction of the due administration of justice. Mr. Todd Engel convicted on those 2 counts. His sentencing recommendation came back at 18 to 22 years. And Todd's case is unique because he simply showed up to the Bundy Ranch. He came to support his fellow man. He walked over to the bridge and saw weapons pointed at him, and he immediately ran to a Nevada highway patrolman and pointed out what he was seeing, and he's seen on dash cam for about an hour and a half talking to law enforcement. When it's all over, they shake their hand, slap his back, send him on his way. And he was convicted and is now looking at 20 years in prison. His sentencing will come up in September.
Anthony?
So Jeff Sessions approves the way that the U.S. Attorney's charges this, I guess is what I would say.
Anthony, when you say words to the effect, and you'll have to reiterate, that they are being charged for exercising their First Amendment rights, can you expound a little bit on what you mean when you say that?
Well, I mean, we have a fundamental right to peaceably assemble and to address our government for the redress of grievances. And that's what people did in Bunkerville in 2014. They peaceably assembled to air a grievance with the federal government. And the federal government, the Bureau of Land Management, erected a fence under a bridge in a wash. And naturally, when people go to gather and to protest, they go to where the people they want to protest against are. The government erected a fence. The people showed up and they protested. They had signs. There were cowboys on horseback who came to drive these, what everybody thought were abandoned cattle, back to the Golden Butte allotment. And they roll in and they find instead there are dozens of heavily militarized, quote-unquote, land management agents pointing weapons at them, and everyone perceived a threat to use lethal force. That's a First Amendment right. You have a First Amendment right to go where the government erects a gate and say, hey, we don't like what you're doing. We think that what you're doing is heavy-handed. And doing that in conjunction with being in lawful possession of a firearm is being criminalized in the District of Nevada in Las Vegas right now.
That's what now I'd like you to expound a little bit on the law that you were explaining yesterday. Congress has passed that the judges can then use with regard to firearms, that
Sure.
Makes the judge capable of depriving the defendant of even bail.
Yeah, so basically what happens is there's a section of the United States Code, it's Section 924, Paragraph C, and in 924C, the title is Use and Carry of a Firearm in Relation to a Crime of Violence. So you don't actually get charged with 924C. What happens is, in this case, for example, they would say that the defendants engaged in interstate travel in aid of extortion. And the government will say, okay, extortion is a crime of violence, and these individuals were in possession, lawful possession of firearms. So let's charge them with Section 924C, use or carry of a firearm in relation to a crime of violence. Here's the thing about Section 924C. Congress wrote this law with the intent that repeat offenders would be punished severely. And a lot of the section deals with drug crime, but it's worded in such a way that if the government thinks that you've committed a quote-unquote crime of violence, you're in possession of a weapon, they can punish you more severely. So Section 924C is worded that after your first offense, there's a 25-year mandatory minimum that has to be served consecutively to any other charge on your indictment or what you've been convicted of. So what the Department of Justice does is they will take and they will charge you with Section 924C multiple times for the same event. So when this indictment came down for the events at the Bundy Ranch in April of 2014, the government stacked 4 counts of Section 924C on top of 4 of the other charges that they claimed were crimes of violence.
Do you know when this law was passed by Congress?
Let's see. Section 924C has been in existence for a while. It's undergone some revisions through the 80s and 90s that basically deal with some of the mandatory minimums. So I'm not 100% sure of the exact genesis of when
Okay.
it landed in the U.S. Code.
Well, forgive me for interrupting, but get back to now the judge's discretion with respect to that one when someone's charged.
So the way Congress has this worded is the judicial system says they have no authority to deviate from the mandatory minimum. And so the mandatory minimum is 5 years for the first offense, or 7 if you were convicted of brandishing a weapon, and then 25 years for each one after. So Mr. Burleson was convicted on 3 counts of 924C. The first one carried a 7-year sentence, followed by 25, followed by 25 more. 57-year mandatory minimum that has to be served consecutive as opposed to concurrent. It has to be served consecutive to any other convictions. And so 57 years right out of the gate, no matter what. And after that, the sentencing guidelines take effect, and he was given 135 months for the other charges. It comes out to like 70 years and 3 months. And the judiciary, supposedly, has no wiggle room when it comes to statutory or mandatory minimums.
And we learned in Oregon what happens if a judge gives you a sentence because to do otherwise would shock the conscience. That's what happened up in, that's what prompted the Mayor Oregon standoff is a judge deviated from the congressional provisions, sentencing guidelines. And
yeah, you're absolutely right. That was the U.S. attorneys, the Department of Justice, charged 2 ranchers with a statute that had been enhanced as an anti-terrorism statute following the Oklahoma City bombing in 1995, the Anti-Terrorism and Effective Death Penalty Act of, I think, 1996, stiffened some of the charges, and one of them was for arson. And the thought was, if someone is going to intentionally or maliciously burn down a government-owned facility or government land, if they're going to capriciously do this, we're going to punish them with a 5-year statutory or mandatory minimum. The Hammonds, in agreement with the Steens Act of 2001, STEENS, the Steens Act of 2001 specifically said that the western red juniper was an invasive species that had to be controlled by rangeland fire, and that the Bureau of Land Management and ranchers would work together to accomplish this. Bureau of Land Management did not help the Hammonds with that. They set a couple of backfires. They burned 150 acres of western land. And again, if you've been in the West, 150 acres is absolutely nothing. The BLM burns more of that every year in rangeland management. Hammond set a backfire. They burned some land on the BLM, and they were charged under this anti-terrorism and effective death penalty statute. And the judge who sentenced them said to give them the 5-year mandatory minimum would absolutely shock the conscience. And so he gave Dwight Hammond, I think, 3 months, and he gave Stephen Hammond 1 year. They went to prison, they served their sentence, they came home, and when the statute of limitations was about to expire 10 years later, the Department of Justice comes back and appeals to the Ninth Circuit and says the judge didn't have the right to give them less than 5 years. We want them remanded to prison to finish their sentence. That's what they did.
so when Congress passes a law dictating what a prison sentence shall be relative to a particular crime, the judge has to follow the law. And so that's...
The judge...
Go ahead.
Yes, the judge has to follow it, but the Department of Justice uses these laws. You take Greg Burleson, for example. 3 counts of 924C. There was 1 Bundy Ranch. There was 1 protest on April the 12th. There was 1 Greg Burleson. He had 1 lawfully possessed rifle in his possession on 1 day for 1 event, but they charged him 3 times, and it resulted in a 57-year mandatory minimum on top of anything else that sentencing guidelines would recommend for what he was convicted of. That's how the Department of Justice uses a congressional mandate to apply an avalanche of litigation against people. And we were talking yesterday, it's really subjective, because there was a motorcycle club that came in on a RICO count, 23 of them. They're charged with racketeering, murder, kidnapping, grand theft auto, and 2 counts of 924C, 1 in relation to the crime of violence of murder. They were in prison for 48 hours, and they enjoy the right to the presumption of innocence. If you're a motorcycle club charged with a racketeering under the RICO Act, you enjoy the presumption of innocence, and you get pretrial release.
Are you saying that this particular law changes the presumption of innocence as it's applied to the people that have been indicted relative to Bunkerville?
The law doesn't change, but the way that it's applied is selectively applied. If your last name is Bundy and you stand up to the federal government, and by extension to the judiciary, there was a court order to round up these cattle. So if you stand up to the federal government, they will charge you, and you are in lawful possession of a weapon. And by the way, not everyone else was, but because of conspiracy and aiding and abetting, they can charge anybody they want who was there that day with the entire same litany of crimes.
I want to go back just for a moment to the presumption of innocence, because it seems that these men that are imprisoned don't enjoy the presumption of innocence. They're not allowed out on bail, and there's no access to habeas corpus?
No, and I can explain exactly how that happens. It's basically what happens is Congress passes a law, and congressmen and women want to be known as being tough on crime. That's the bottom line. They want to be known as being tough on crime. The Department of Justice doesn't want people to go to trial because it's expensive, so they'll charge you with crimes in such a way that nobody wants to roll the dice. They have an effective 95% conviction rate because nobody goes to trial. Because if you do, you're effectively rolling the dice with the rest of your life based on the way they charge this. So if you come back to the 924Cs and the presumption of innocence, you have something that's called the Bail Reform Act of 1984, back in the height of the war on drugs. And in the Bail Reform Act of 1984, there was a provision modified that basically said, okay, when somebody comes in for a sentencing hearing, so the government indicts you and they arrest you, within a couple of days you get a sentencing hearing. And that's where a judge decides whether or not you go home on pretrial release or if you stay in prison on pretrial detention. Well, buried in all the provisions of the Bail Reform Act of 1984 is one little blurb that says, by the way, if you're charged with Section 924C, this, in and of itself, gives rise to the rebuttable presumption that no set of circumstances exist that will reasonably assure that you will return to stand trial in the district where you're charged. The government knows this, and so the Department of Justice will charge you with 924C and know that they can effectively argue that because you participated in a crime of violence with a weapon, that's how they'll word it at your detention hearing, a judge will then say, well, in that case, you're a danger to society, and let's keep you in prison until you go to trial. And normally you would have 70 days under the Speedy Trial Act, but in this case, because there's 17 defendants, the government just declares it a complex case, and your right to a speedy trial vaporizes.
There's a law that carves an exemption out of a speedy trial and otherwise rights to speedy trial, a due process right to speedy trial. You're saying that there's some law that negates that if the judge declares a case complex? Is that what I heard you just say?
Exactly. That's exactly what happened. They were picked up in March. The first group of people were slated to go to trial in May of 2016. The government moved the court to declare the case complex, and when that happens, your right to a speedy trial vaporizes.
How is that not an unconstitutional law?
It is absolutely. You have to look at this from the vantage point of the judiciary. The judiciary sees the Constitution as that living, breathing document, and they, drunk on their own power, believe that their case law is an effective manifestation of the essence of the Constitution. And they have case law to back up the fact that they can detain you nearly indefinitely under these charges, vaporize your right to a speedy trial by declaring your case complex. And the government has even said in proceedings that they feel confident they can keep someone for up to 5 years without running into any constitutional hurdles.
Okay, I haven't looked at this particular provision in the Constitution for a while, but isn't that the exact verbiage? Isn't right to a speedy trial the exact words in the Constitution?
Right, to a public speedy trial. That's another issue. All of the evidence is sealed in this case. We're not allowed to see what evidence, quote, the government has against Mr. Bundy and his supporters.
You mean? Do you mean the public isn't able to see it, or the defense wasn't able to procure it through discovery?
Well, a little bit of both. The public is definitely not able to see any of the evidence. All the evidence in this case has been sealed. And they said that's to protect the identity of the law enforcement individuals involved.
I don't understand. Hang on. Whoa. I don't understand how you seal evidence from the public. You mean during the course of the trial, when the evidence is being presented, the public's not in there listening to it? Or explain what you mean by that.
The public is welcome to go into the courtroom and see what evidence is admitted for trial. But the entire whole of the evidence procured by the government, and it's all digital, and it lives on a hard drive. It's about 2 terabytes for those of you who understand hard drive capacities. There's 2 terabytes of digital evidence in this case,
which is a lot.
And it's a lot of evidence, and the public is not allowed to see all of that evidence. It's under protective order.
Are you saying? I'm shocked. Hang on, this shocks the conscience. Are you saying that the jury is going to have access to this evidence, but the public is not?
The jury doesn't even have access to all of it. For example, yesterday we were in court, and there's an agent testifying who was actually going to kill a protester. Taking his safety off of his weapon and was taking tension out of the trigger, ready to kill a protester right there on the bridge. This individual is seen on body cam. There's a piece of evidence in body cam, and somebody walks up behind him, and he's got his rifle laid over a hood, and he's using his scope to point out a protester that he's going to kill. And he says on the body cam, this is pretty much a shoot first and ask questions later proposition. This is what the guy says on body cam. The defense tries to bring the body cam in yesterday on cross-examination. The government objects, and through a sidebar, which is where all the attorneys and the judge go off to the side and discuss things, they come back. They can only play the video on mute. And they're not able to show the jury that this guy, who was ready to kill a protester, had the attitude, this is a shoot first and ask questions later proposition.
You are an eyewitness inside the courtroom to what you just said. You're saying that the judge is not allowing. Now, did the prosecution make some sort of motion to suppress evidence to enable them to exclude this evidence? Or
yes, that's what the government does. They will, when you get ready to enter evidence, they will object. And there's case law, or there's federal rules of criminal procedure. There's ways that they can wrangle to argue that it's more prejudicial than it is probative for the jury. But you tell me how an individual who's about to kill somebody, whose attitude is, well, this is a shoot first, ask questions later. Tell me how that's not relevant. I'll never say another word about it. But you can't. And you have to understand that is just one example of something that happens routinely in this courtroom to these individuals as they try to make the defense. In the first trial, they went to trial once in February of 2006. They had 30 people on their witness list. By the time it was their turn, they were down to 2 witnesses. And the way the government was able to do this is they were able to say to people who they called, by the way, there are people who are known and unknown to the grand jury who are unindicted co-conspirators. Let that sink in. Unindicted co-conspirators. They would say this is an ongoing investigation, and this witness needs to know that whatever they say could incriminate them and basically cause them to land on the next indictment. And so you had people who didn't want to testify because they were intimidated by the fact that they too could be indicted. By the time it was all said and done, they went from 30 witnesses to 2, and one of the defendants had to take the stand in order to get the entire story in front of the jury because the government had wrangled to make sure that evidence couldn't come in. It forced one of the defendants to take the stand, expose himself to cross-examination in order for the jury to be able to hear the truth.
Anthony, I just got a couple of minutes left. So what is the answer to this madness?
I was telling David yesterday that we have a responsibility for an ideological revolution. We have got to educate the American people about what's going on. We have got to show them that their First and Second Amendment rights are absolutely being criminalized in the District of Nevada. This is a huge case. It's going to go to appeals. It's going to end up in the Ninth Circuit and probably at some point in the Supreme Court. Our children and our grandchildren will look back at USA versus Bundy, and they will see it as a constitutional watershed. We have a responsibility to educate every freedom-loving American that esteems the blessings of liberty as something, a God-given natural right. Everyone needs to educate themselves about this, support the Bundys, support people who stand up for constitutional rights, and tell the government, the legislators, U.S. attorneys, the judiciary, that this isn't going to work.
Because this has fallen on deaf ears, Anthony, even with the politically correct right-wing media.
People don't realize, I don't think people believe us when we say when we describe the level of injustice. I don't think people believe it until they go into the courtroom and see it for themselves and see how our rights are being criminalized. It's a terrifying proposition to sit in there every day and know that this will become case law.
And by the way, Anthony, what about Ryan Zinke? Could he help?
I think anyone in Washington, D.C. could help simply by making some waves. I really thought that Jason Chaffetz or Trey Gowdy would pick this up and kind of champion this cause and investigate the heavy-handedness of the Bureau of Land Management, U.S. Park Police, Fish and Wildlife, Forest Service, and nobody in Washington, D.C. Seems to want to touch it for reasons none of us can really discern.
I think the only way out of this is through a presidential pardon. I think that there's no stopping this without the president stepping in.
I got to run. Anthony, thank you so much. Idaho Political Prisoner Foundation is the name of the organization. Thank you very much for your interview.